morning. We commend all of you for your hardiness, but we commend you equally for your hardiness.
Good to be here.
SJC-11766, Commonwealth versus Christopher Kostka.
Chief Justice Gantz, Justices of...
Hang on a minute.
Oh, I'm sorry,
She's
Judge.
going to set the clock.
Chief Justice Gantz, Justices of the Supreme Judicial Court, I am John Henry Cunha, and I represent Christopher Kostka. We are here appealing a finding of contempt brought against Mr. Kostka in the Suffolk Superior Court. There are two major problems of constitutional dimension with this case. Suggest that one of them is the process. It's substance as well, but the process by which the order to give the DNA sample was issued, and the second is with the interpretation of Draheim, which we suggest is overly broad, and Draheim itself, as this court recognized, I believe this court described it as a novel question, and it's not surprising, I'd suggest, that additional questions would arise. One such question, for instance, is relevance alone, or do you have to have materiality? I noted that in the South Carolina case cited by the government, which is State versus Register, 419 SE 2nd 771 at page 773, South Carolina has a similar standard, but they require materiality. That is not a requirement of Draheim.
Now, tell me how that matters here.
Because many things are relevant, but that doesn't mean that they are so relevant that they should allow constitutional incursion, an incursion into the body. Our suggestion here, for instance, if you take the facts in this case, which, first of all, we still don't know, we being Christopher Kostka, what the DNA results were, except in a very cursory fashion. We don't know what the DNA results were with respect to Timothy Kostka and the victim at the crime scene. They tell us all that we know is that he's partially included and cannot be excluded, that is Timothy. What does that mean? All siblings share 50% of the DNA with their other siblings. If they have very little DNA, what does it avail them to test Christopher to determine if he is a fraternal twin, if he could share those alleles in any event? The notion that the government should be able to just go in there and give the offhand hope, wish, and a prayer, we think he might possibly be his identical twin, absent not a scintilla of evidence.
But looking at it from the other perspective, though, it seems to me that's a bigger problem, isn't it? I mean, unlike Draheim, where clearly the people being tested were the victims, and there was no
that was the
question.
Allegation.
Right.
Yeah.
But here, it seems to me if the testing were to show, contrary to his statement, to your client's statement to the grand jury, that they were identical twins, he's clearly a suspect, right?
In that case,
this stuff is found underneath the victim's fingernails.
Absolutely. In that case, there's a higher standard.
Well, that's it seems to me that's a bigger problem, really, than the materiality.
Well, we do raise that in our brief, and I totally agree with you, Judge. But just to start at the beginning, what did they show this court? What did they show the trial court? Nothing. They had not one bit of evidence that suggested that they were identical twins. They said, we just want to see if they are or they aren't. And the notion is that because it's relevant somehow, I disagree, and we've laid that out in our brief as to the relevance. However, as a matter of institutional concern for this court, what is the standard by which the lower courts are allowed to take DNA evidence that is an abrogation of somebody's constitutional rights.
Well, let me play it out in a slightly different way.
Yes, Your Honor.
What if the DNA recovered from the scene was in fact, or at least scientifically, was Timothy's DNA? You would still be arguing that there should be no intrusion into your client.
Correct.
But
there are different problems here, Judge.
Yeah. Now, but play it out one step further. What if we have a trial? If you prevail here, we have a trial,
Yep.
And the defense is third-party culprit, and it is my twin brother.
What's the good faith basis for that?
I have no idea.
I
I have no idea, but Timothy may say that it wasn't me. I believe it was my brother that did it because of a comment he made. Would the Commonwealth then be in a better position to test your client's DNA?
First of all, Judge, on the facts presented here, I understand.
Yeah, I understand the facts presented
Right.
here. I'm just trying to figure out if you get to the point where there is a third-party culprit defense, could you then, would the Commonwealth then be in a position to ask for your client to submit to a buccal swab test?
Yeah, mid-trial.
Mid-trial.
What Superior Court judge, first of all, if it was known beforehand, which it clearly is, what Superior Court judge would not allow a motion in limine by the government saying, absent a good faith basis for saying that they're identical twins, they can't present evidence that he's got a twin brother? Why? That's a very simple, non-constitutional solution. What's the problem with that? The notion that the government can start fishing around in somebody's body because they want to make sure he's not is absurd.
But a buccal swab is really not very intrusive. It's the least intrusive test that you can conduct. And if we have to postpone a jury trial to have a buccal swab, then aren't we working at counter purposes here? We've wasted perhaps several days of a jury not being able to sit on a case while the testing is being done. That's why my question to you is, would the Commonwealth then be able to obtain the testing if there were a third-party culprit defense?
If there were, then it would have to be a good faith defense.
Let's assume it was a good faith defense. Would the Commonwealth be in a position to get the buccal swab from your client?
If it was a good faith defense, Judge, then there would be evidence that suggested they were identical twins. For instance, they look alike. They're spitting images of each other. They're the same height, maybe not the same weight, that can be variable. But there would be evidence that they were identical twins. There is no evidence of that.
Okay, but assuming that there was.
If there were.
Say the Commonwealth could get it?
I would suggest that still the defendant, Timothy, would still have to say to a judge that there's some evidence here that would
let's
implicate.
assume, hypothetically,
that would
that he
implicate
did.
Christopher. There has to be something beyond the DNA.
Okay, and they do. He can do that.
Well, that's a very different question. And frankly, I don't really know the answer to that, Judge. But that's a very different question. You're going from the scenario here where there is absolutely no evidence that they are.
Right, but I thought that was Justice Spina's question.
I understand. But what I'm suggesting is that absent some evidence that they are identical twins, no, they should not be allowed to do it.
Well, play out your scenario. Let's assume we say, okay, you can get it, but only if the Commonwealth first files a motion in limine, as you suggest, and the defense does not object to it, or the judge decides to grant the motion in limine. But what if the judge decides? What if the defendant objects to it, and the judge says, "I don't really know how the evidence is going to play out at trial. I'm not going to allow it at this stage." Then can they get it?
If the defense objected to it, they'd be objecting to it based upon actual evidence. The proponent of the
So should we basically say the Commonwealth first must file a motion in limine, and only upon the denial of that motion may they then get the buccal swab?
I think, Judge, that what we have to say is the government has to, as they're moving for a constitutional intrusion, and I understand, as Justice Spina has suggested, that it is not the most they're not sticking a needle in your arm, et cetera. However, the level of incursion into the body, the level of violation of the Fourth Amendment, I'd suggest should not be a factor at all. Sticking a tracking device on a car is not a great intrusion, but it's not legal.
But try my question. Let's assume we view it as we do, as a constitutional intrusion. And let's assume we say you must first explore the possibility of avoiding the constitutional intrusion through a motion in limine, and let's assume for whatever reason it's denied. Then where are you?
If it's denied, then presumably it would be denied because the government would have evidence that it could present to a judge. The law is clear. When the government seeks evidence of
If it's denied, it's because the defense contends that.
Maybe I misunderstood.
The motion in limine would be, Your Honor, we move in limine for the defense, as you suggested, to be precluded from offering evidence, even that he has a twin.
Yes.
And that obviates the need for any of this. That the defendant agrees that it will not argue to the jury that he has a twin, will not make no mention of it.
Yes.
If that motion is denied,
it would be
then what?
Judge, I can only assume it would be denied because there would be some evidence that the defendant would be able to say to the Superior Court judge, that we have a good faith basis for this. The good faith basis for it is that they are identical twins is A, B, and C, or A, B, C, D, whatever it is. That's the same evidence that the government, if it seeks the constitutional intrusion, as the moving party to get it, it's their burden of proof and their burden of persuasion. If there is that evidence, they can employ that evidence to ask the judge to take the DNA. Then you have a very different scenario. You have actual evidence. That's why it would be denied. No judge is. I suspect that no Superior Court judge is going to say, "I'm going to allow you to make a bad faith argument here, defendant."
Well, it's not a bad faith argument. It's a cross-examination. Isn't it true that my client has a twin? Yes, it is. Okay.
Judge, I think that is. I think that there is certainly, arguably, is a bad faith argument. If there's
bad faith question, it would be.
If there's no evidence. If there's no evidence that they're identical.
But couldn't the Commonwealth, if that were to happen, couldn't the Commonwealth call your client to say, as he did before the grand jury?
Absolutely.
Yes, I'm a twin, but we're not identical twins?
Government put him before the grand jury.
Your client takes the fifth.
If he takes the fifth, then I think that, now we're getting into the law of when grand jury testimony can be
I'm just really wondering what the dynamic is here. I mean, the Commonwealth obviously expects something to happen. They are acting in anticipation of that. You're saying that none of that will happen. Couldn't possibly happen.
I don't think it can happen, Judge. Not in a good faith defense.
If they had some good faith stuff, would you say that in order to get your client's DNA, they would, as in Levine, would need to have probable cause?
If they're suggesting that he might be
But I suppose if they've got evidence that he's an identical twin,
then it would be inculpatory evidence as to him.
And then you would need to meet the Levine standard.
Correct.
We're making certain assumptions, though, that probably correct, that identical twins and fraternal twins do not have the same DNA. But don't you need an expert to say that? You can't get Joe Schmo off the street to say, geez, everybody knows that, fraternal twins don't have the same DNA. So in the middle of a trial, if there is this defense, then the Commonwealth would have to ask for a postponement to hire an expert to come in and give that general proposition that fraternal twins don't have the same DNA. Isn't the practical solution to this, especially where it is so minimally intrusive, to have the buccal swab done now?
I don't think that practicality should trump the Constitution of the United States.
Well,
or
it's
Article
not trumping
12
it. It's a factor that goes into the analysis.
Well, Judge, first of all, the government presented evidence here in the form of an affidavit. They've got plenty of people that they call upon who say that. Now, the expert just said that in the affidavit that they presented said that identical twins have the same DNA. That's why they look exactly alike, obviously, which is not the case here. But they didn't. What they didn't say, which is commonly known, is that 50%. We each take half of our DNA from our parents, and from each of our parents, and as a result, siblings all share not the same 50%, but 50% of the DNA with each of their parents and with their siblings. Now, that is of far greater import here than anything else, simply because we don't know how much DNA is that was under the fingernails of the victim, what belonged to Timothy. Is that telling me I got to sit down?
You're very astute.
I rest on my brief.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Teresa Anderson on behalf of the Commonwealth. With me this morning is Assistant District Attorney Ursula Knight. We're asking this Court to affirm the judgment of contempt in Judge Locke's order, compelling the contemnor to submit a DNA sample. I'd like to make 2 points very clear. First, in this case, the Commonwealth satisfied the Draheim standard for a third-party non-suspect. And second, the Draheim standard is the appropriate...
But it's different. I mean, potentially... he is a suspect if it turns out they're identical twins, isn't he?
No, he's not. If it turns out he's identical twins and therefore his DNA is included and unable to be excluded from the sample, that's what it tells us. Well, it tells us that much, that he could be a contributor to that mixture. It's then in the totality of the evidence and all the other evidence in this case that eliminates him from being a suspect. It is not our contention that the contemnor, that the twin brother, is a suspect.
Doesn't that cut against you, though? That means that it's not that important.
No, and so this is where I think the Court needs to look at this evidence in 2 different ways. And there's 2 different ways that you can see the relevance of the defendant and the contemnor's DNA profiles.
It's easier if you just use their names, I think. Okay. Timothy and Christopher?
Certainly. Christopher Kostka's DNA will provide relevant evidence and answer the question whether the defendant, Timothy Kostka, has an identical...
No, the defendant is Timothy.
Yeah, correct.
The defendant is Timothy or the defendant is Christopher?
Defendant is Timothy Kostka. So whether or not Timothy Kostka shares an identical DNA profile with another person. That is what the Court needs to... that is what this evidence is relevant to. That is what the Commonwealth is seeking Christopher Kostka's DNA sample to answer the question whether or not Timothy Kostka has an identical DNA profile with another person. And that's important when presenting that evidence at trial.
Okay, I don't understand why that's so important.
At trial,
if it flips when you say about the brother Christopher not being able to be a suspect, if it's shown that he has identical DNA, then why is it significant to Timothy's prosecution that he shares the DNA with Christopher?
The DNA is one piece of the evidence that the Commonwealth will present at trial to establish the identity of the perpetrator. And in combination with other forensic evidence, with other eyewitness evidence, with other evidence in the case, it will establish that the defendant is the perpetrator of this homicide.
Because you're worried that somebody might be able to say you couldn't establish it conclusively as long as there's a possibility that he has an identical twin?
No, it's allowing the defendant to poke a hole at one piece of the evidence, to poke a hole at the DNA identification evidence and say it's not just Timothy Kostka's DNA, that somebody else could also be included and unable to be excluded as the contributor to that mixture. And that's Christopher Kostka, by virtue that they are twins. And that is certainly explainable.
By virtue of being identical twins.
Correct, identical twins. And that's certainly explainable, and that's a piece of the information, and that's what the Commonwealth needs to present a full, a complete, and an accurate evidence with respect to DNA. Again, one piece.
So every time there's a defendant who has a twin, that twin needs to have DNA testing?
Yes, where the DNA evidence is relevant in the case. I don't think all cases, right? It's in this case where the Commonwealth will use DNA evidence to identify the defendant as the perpetrator.
So
It's
whenever
in
it's
this
to
case.
identify someone as a perpetrator, if that person has a twin, the Commonwealth will be seeking to do DNA testing of the sibling.
Yes, because it meets the Drawheim standard of a
So why should we not then require you to do a motion in limine first? The motion in limine that would bar the defendant from offering any evidence or making any mention of there being a twin.
On one hand, I'm not sure that all defendants would not. I'm not sure whether it's allow or deny them, would acquiesce to the motion in limine. There's certainly
they may not,
certainly,
but why not make that a prerequisite to your getting a buccal swab, because that would obviate, you're claiming it's relevant, and I see your point, but it's relevant only if you need to fear the possibility of the fact of the twin coming into evidence.
And I think it's that twin coming into evidence that can come in a couple different ways. One, if it's a whole third-party culprit defense, that's one thing. But I think it's still relevant, and that's where the motion in limine might come in, but it still is relevant on that lingering doubt of, is there another person that has the exact same DNA profile as this defendant, as this person who's being charged and being identified as the perpetrator by DNA?
How would that come in if the motion in limine is allowed? How does that come in? Just sort of run that examination.
I think you do have the practical problem in this case of the defendant's twin brother will likely be called as a witness, and then you reach the availability issue or not. I'm not sure that it's a fact that can be ignored.
Likely be called as a witness if you don't get the buccal swab? Is that what you're saying?
For other reasons, yes. And
okay,
that's
so he's
connected to the case?
called as a witness, and he testifies he's the brother.
And he doesn't look anything like the defendant.
And that's and I appreciate that they don't look alike, and that is one piece here. But the only way to conclusively establish the relationship of twins is with a DNA test.
You say he's connected to the case quite apart from this DNA stuff?
In a factual and as a background matter, yes.
Well, then doesn't that make it more of a culprit possibility here?
No. And
Why
again,
do I have to accept your? I mean, I'm not challenging you, but is it enough for the prosecutor to say no, we're not going to go after him? I mean, I don't know.
I think it is, and I think, again, you look at the Drawheim standard. It's not even that, for a third-party suspect, it's not even that different than a...
But he is in a very different position than the people who were tested in Drawheim, I think.
And he is in a different position, yes, but he is still... His sample will probably provide evidence relevant to the question of the defendant's guilt. And it's that standard, my second point here that I'd like to make is that standard is appropriate. That standard balances the rights of the third parties with the Commonwealth's need to investigate and to obtain relevant DNA evidence.
How does it balance it? I'm not seeing any defense whatsoever to having the Commonwealth come in and just take a buccal swab. I mean, what can you say? Christopher says, we're fraternal twins. They don't look alike. And yet the Commonwealth presses on.
Right.
And so there's no reason. I'm not seeing the balancing here.
Because here we meet the standard, both of...
Well, that's the standard so far.
And it's a correct standard because it is the same standard that a defendant needs to show to obtain a DNA sample from a third party. It's not just the Commonwealth. It is the same standard in Ray Jensen that this court has said for a defendant to obtain a third party's DNA. It's this probably provide evidence relevant to the question of the defendant's guilt.
So then let's turn this around a little bit. Say it's the defendant that wants to get a DNA sample, presumably to establish that his twin is an identical twin.
Sure. Same standard. Probably provide relevant evidence on the question of the defendant's guilt. And there's three parts to that standard. It takes from the Rule 17 relevant evidence, and that's what you have. You have people that are included or excluded. It's relevant evidence.
But do you...
Go ahead. I was going to say, isn't there some nexus to the crime in Jensen?
Yes.
And there's no nexus to the crime here.
The nexus to the crime here is that Christopher Kostka twin brother is charged with the crime. Again, the primary purpose...
Nexus of the third party to the crime.
But in Jensen, are you suggesting the Commonwealth could have gotten that test as opposed to the defendant?
Yes.
Really?
Probably provide evidence relevant...
Wasn't Jensen another defendant in that same coterie of things?
Jensen is co-defendants and a third party. Victim identifies co-defendants as the two assailants.
But all right, you might get it, but you'd have to show probable cause, wouldn't you?
If the question is whether or not he's a suspect, if it's at that point it is...
I mean, I don't think it's the Draheim standard that it would apply.
I think it'd be the same as the grand jury investigation standard. So that's in re grand jury investigation, and it's a reasonable basis or probable cause for believing that the DNA sample will provide results that significantly aid in the investigation. I think that would be the standard in that case for the Commonwealth to prove, because it's not, and that's the standard that we have here. So Jensen takes Rule 17 subpoena relevance and adds grand jury investigation standard and puts them together. And the standard that we get is probably provide evidence relevant to the question of the defendant's guilt. Where you have a probability, you have to have the probability on one hand, you have relevant evidence, and it's related to the question of the defendant's guilt.
You know, sometimes we see DNA evidence that says the chances that the defendant will have the same DNA profile as a randomly selected person is 1 in 28 quadrillion.
Yes.
And sometimes we see it where the statistical evidence is he would have the same DNA, or that a randomly selected person having the same DNA profile is 1 in 280 or
Yes.
something like that. Are you suggesting that something like that exists here, and therefore there is a greater need for even any sibling to have the DNA tested?
And that, yes, depending on how you look at the evidence. First, with respect to
Well,
twins...
what is the evidence?
The evidence is you have twins, and the Commonwealth needs to establish whether they are identical or fraternal. The only way to do that is with a DNA test, and that is looking at the 16 locations, the 32 alleles of the defendant, Timothy Kostka's sample, and determining whether or not he shares that identical profile, that in and of itself.
But Mr. Cunha said that there was no evidence presented to the judge below as to what the DNA evidence is.
So that's the second step. So I think first, on one hand, you look at the Commonwealth is looking to compare the Christopher Kostka's DNA with Timothy Kostka's DNA to determine whether those 16 loci and 32 alleles are identical.
Totally independent of the crime scene.
That's it.
That's it.
In and of itself. But I think you can also look at this evidence as evidence from the crime scene. So from the crime scene, you have a mixture where the defendant is included and unable to be excluded. There is no evidence
Partially included. What does that mean, partially included?
It means that he is not included at all 16 locations. It is not in this record as to how many locations he is included. Happy to supplement if this court would like that evidence as well.
I've never seen that before, partially included.
It means his DNA doesn't exist at all 16 locations. It's less than 16.
You mean the sample tested doesn't provide information as to all 16 locations?
Yes, it's a mixture where there are alleles at each, but it might be one allele in one location, not 4. And so the defendant may not hit at that location. He might not be included in all 16.
So the likelihood is going to be much lower than the quadrillion that was mentioned because you don't have all 16.
Correct, but nonetheless relevant. And so here is where, if we wanted to, you have evidence here that another person, Christopher Kostka, there's a probability that another identifiable person, Christopher Kostka, is also included and not able to be excluded from the crime scene evidence. I appreciate that you might need more facts to delve into that, and that's the more, like, how many alleles and so forth. But I think that is a separate question from comparing Timothy Kostka's 16 alleles with Timothy and Christopher Kostka's 16 alleles with each other.
Well, let me ask you, with regard to the Draheim standard, Draheim, in that particular case, the evidence certainly was relevant to the question of the defendant's guilt, because if indeed it was if the DNA of the children was the DNA of the father, then the woman committed a rape of a underage male. But here, it doesn't seem like the standard would work because it's not relevant to the question of his guilt, because even if it's a hit, he's still not guilty. You've already basically said that. It seems that you would need a standard that would say it's relevant to the jury's determination whether the Commonwealth has proven guilt beyond a reasonable doubt. I mean, that's really what you're focused on.
But I think that in longer hand is relevant to the question whether the Commonwealth has proven beyond a reasonable doubt. And it is all three. It is probability, it is relevant evidence, and it is directly to the question of the defendant's guilt. We're not asking to take the next DNA samples from the next 100 people because that would provide relevant evidence. Because in that case, it's not probably likely to lead, it's not probable that it will lead to evidence of the defendant's guilt. This is one identifiable person who may be included and unable to be excluded from the crime scene evidence. Setting that aside, the issue here is whether or not at trial, when the Commonwealth presents DNA evidence that the defendant, Timothy Kostka, is included and unable to be excluded, whether or not in presenting that evidence in a full and accurate and complete way, the Commonwealth can say with certainty that Timothy Kostka does not share an identical DNA profile with another human being.
Now, normally, in the insanity defense situation, or where there's the so-called affirmative defense, there has to be notice of the affirmative defense by the defendant, but the third-party culprit does not require that. So why not proceed, as Chief Justice Gantz suggested, and flush it out?
And I think because both third-party culprit, the notice isn't required, but it's also short of a complete defense. That it's not that the defendant would necessarily prove that somebody else, a third party, committed the offense. It's that there's left with a lingering doubt. There's left with possibly a reasonable doubt that identifies the defendant as the contributor to that mixture underneath the victim's fingernails. It's less than a complete defense. It's not that the defendant is proving that, and that is his defense. It is that the Commonwealth is seeking to eliminate that lingering doubt.
I take it you'd have a more compelling case if DNA was the only evidence connecting Tim to the crime scene, right?
Perhaps, but I think that's where, again, the standard is correct because it also allows for these additional factors to be considered in the analysis. And so additional factors of seriousness of the crime, importance of the evidence. I think that's Your Honor's situation here, is that or hypothetical that if it was only DNA, that would be more important in the measure of proof. And then, of course, the last being the unavailability of less intrusive means. I think.
So, in the course of the scope of a normal, or in the scope of a reasonable investigation, this is the flip side of Bowden. In the course of the scope of a reasonable investigation, the Commonwealth should try to get this kind of evidence to remove that question of doubt.
Absolutely.
Right. Thank you.
Thank you.